Okay, Mr. Glazer, are you ready to proceed with Mr. Clark?
Yes, Your Honor.
All right, this is file 24-21804-FH, People versus Larry Dean Clark. We are here today for a pretrial conference in this case, and we're proceeding partially by Zoom and partially by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. Arnold for the people.
Allison Arnold for the people.
John Glazer for Mr. Clark.
Sorry, okay, so I'm sorry, we had two files today. File 24-21804-FH was set for a show cause hearing on an alleged probation violation. That was dismissed, or the probation officer has to have that dismissed. We also have file 24-22077-FH, and that's the one that's set for a pretrial. So Mr. Glazer, then where do we stand with the
Your Honor, I guess we need to set a trial date on Mr. Clark.
Okay. And so it's let's see, one count of possession of methamphetamine is the allegation. Ms. Arnold, how long do you suspect we'll need for a trial in that case?
Just 1 second, Judge. I just want to. My computer is working really slowly today. A day.
Do you agree, Mr. Glazer, that 1 day would be sufficient?
Yeah, that's going to be pushing it probably, but yeah.
We can set it for a day and a half. I'm not, maybe the defense is going to take longer than I think.
Okay. Ms. Clark, can we have a 2-day jury trial date for Mr. Clark, please?
Yes, Tuesday, September 16th at 9 a.m. and Wednesday, September 17th at 10:30.
That works.
That was September 16th and 17th. Let's do a final pretrial then on September 10th at 8:15.
Okay. That's good.
Okay. The court will issue a scheduling order. Is there anything else we need to address with this case today?
Oh, and I just wanted to check the VOP file was dismissed. Is that correct?
Correct.
All right. Yeah, nothing else, Your Honor.
All right, so Mr. Clark, you're all set for today. Your next date is September 10th at 8:15 a.m.
Thank you.
Thank you.
I think that's all I have with you this morning. Thank you, Judge.
Thank you, Mr. Glazer. Okay, Mr. Goldstein, are you ready to proceed with Mr. Cadell?
You understand the charges against you?
Your Honor, I'm in Judge Ainslow's right now. I'll be there in about 2 minutes, okay?
Okay. Mr. Van Dyke,
Yeah.
can you come forward to the podium, please? Right, this is file 25-52373-PP, Cheryl Van Dyke versus Mark Van Dyke. We are here today for arraignment on an order to show cause for alleged violation of personal protection order. Sir, you are Mark Van Dyke.
Correct.
Mr. Van Dyke, have you received a copy of the motion in order to show cause?
I don't recollect it. Possibly.
The bailiff hand you a copy of that document.
Yes, I did get those.
Okay.
I did not receive a court date when I was served this, so there was no court date attached to it.
Yeah, we had one previous hearing, I think, on this, and you were not here, so we rescheduled that for today. The motion to show cause alleges that you violate the personal protection order by having contact with Ms. Van Dyke by blocking her from passing the road and yelling at her. The maximum possible penalty for a contempt of court is up to 93 days in jail and or a $500 fine for violation of personal protection order. You do have the right to be represented by an attorney here today and at any other proceedings that we have regarding this matter. And if you can't afford an attorney, you can tell me that and I'll appoint one for you at public expense. Do you understand that?
Yes, I do.
Do you want to be represented by an attorney today?
Yes, I do. I also have some questions leading up to this.
I'm not going to answer any questions. You've asked to be represented by an attorney.
Right. Okay.
Do you have the ability to pay for your own attorney?
No. Possibly, but rather not.
All right, so it's not a matter of whether you want to or not. It's a matter of whether you can or not.
I really don't know at this time whether I can or can't.
Okay, have you been screened by the public defender's office? I think last time you were
I
here.
have not.
Well, didn't I direct you to go over to the public defender's office and contact them?
I believe so.
So why didn't you do that?
I went there and they said I should just come here and deal with it today. That's what I was told. Now, maybe I didn't get here on time. Not really sure about that.
All right, when our public defender gets logged in, I'm going to have her screen you. So take a seat back where you were and I'll have you speak to the public defender when she gets here.
Okay.
Mr. Goldstein, were you ready with Mr. Cadell now?
Yes, Your Honor.
Okay, Mr. Cadell, you want to come forward? This is file 25-22244-FH. People versus Deshan, Elijahan, Cadell. We are here today for a pretrial conference in the case, and we're proceeding today by partially by video conference and partially in person. First, can I have the attorneys place their appearance on the record, beginning with Mr. McCready?
Morning, Your Honor. Dave McCready for the people.
David I. Goldstein appearing on behalf of the defendant.
All right, and Mr. Goldstein, where do we stand with Mr. Cadell's case today?
Your Honor, an offer was made by Mr. McCready At this point, my client is not prepared to accept that offer. So I would suggest we set the matter for trial because I assume it's going to be a ways out. That would allow us to continue negotiating, and if we can't get a resolution done, then we've got a trial date set.
Okay, Mr. McCready, how long you believe we'll need for a trial?
I think a day would be sufficient.
Do you agree with that, Mr. Goldstein?
I think probably right, Your Honor, but I'm always wanting to come down on the cautious side and say maybe 2, but probably 1.
I think 2 to be safe is fine.
Okay, Ms. Clark, we have a 2-day jury trial date for Mr. Cadell, please.
Tuesday, September 23rd at 9 a.m. and Wednesday, September 24th at 10:30.
Yeah, let me check that. I know I've got trials in September, but let me check. No, you said the 23rd and 24th, that's fine.
It's fine for the people as well.
So let's do a final pretrial then on September 17th at 8:15.
Okay, got it.
All right. Court will issue a scheduling order. Mr. Cadell, then your next date is September 17th at 8:15 a.m.
Thank you, sir.
Great, you're all set.
Thank you, Your Honor.
Thank you, Ms. Goldstein. Okay, Mr. Hagglethorne, are you going to need a breakout session with Mr. Nimer?
Yes, Your Honor, that would be helpful, I believe. Should only take a few seconds.
All right, give me just one moment and I will get that set up. Okay, Mr. Mawad, I have Mr. Knight here. Are you going to need a breakout session with him?
No, Your Honor. We're going to ask if it's okay for a couple more weeks. There's been an offer made, but I've got to run guidelines But I have talked to Mr. Sneed, so we were just going to ask for a couple more weeks.
All right, this file 25-22188-FH, People versus Harold Leroy Knight. We are here today for a pretrial conference in this case. Proceeding today by video conference. First, may I have the attorneys place their appearances on the record.
E.V. McClure, map the people.
Your Honor, Elias Muad appearing on behalf of Mr. Knight. Your Honor, I did talk to the assistant prosecutor handling this case. He did text me an offer recently. I want to look at that offer, run some guidelines, see if there's anything else I need to talk to the assistant prosecutor about. So we're just looking for a couple more weeks, nothing too long.
All right, Ms. McClure, is there anything we need to address from the people's side?
Nothing to add, Your Honor.
Let's go then with July 9th at 8:15 a.m.
That's perfect, Judge. You want me to do the order?
Yes, please, I would appreciate that.
All right. And can I sign your name, Phoebe? Is that okay?
Yep, no objection.
Okay.
Okay, so Mr. Knight, your next date is July 9th at 8:15 a.m.
Okay, thank you, Your Honor.
And then, but I did get what you sent me, but we'll talk a little bit later, okay?
Okay,
All right. Thank you, everybody. Thank you.
thank you.
All right. See if they have another room at the jail available. We'll take Mr. Edwards.
I'm telling judges. Do you have another room available that we could use? Okay, could we get Edwards in the room, please? Thank you. Bye-bye.
Okay, Mr. Fry, do you need a breakout session with Mr. Edwards?
Do you want one, Mr. Edwards?
Yes, please.
Okay, 1 second. Good morning, Mr. Dagger Margosian. I have Mr. Miller is here in the courtroom in person. Are you going to need to speak to him?
Your Honor, I would like to speak with him if that's okay.
All right, Mr. Miller, if you'll step outside, there's an iPad just to your left. I'll put you in a breakout session with Mr. Dagger Margosian. Send you a request to unmute Mr. Miller. Okay, give me just a second and I will put you in that breakout session. Okay, ma'am, I need you to shut the phone off. If you're gonna use the phone and it's gonna make noise, you need to be in the hallway. Okay, this is file 25-22177 FH and 25-22178 FH. People versus Earl Edwards. We are here today for a pretrial in each of those files. There are also pending contempts in each of those files. We are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. McCready.
Dave McCready for the people.
Good morning, Your Honor. Brian Fry, appearing for Edward Edwards.
All right, and Mr. Fry, where do we stand with Mr. Edwards' cases today?
Your Honor, we would ask that we get a trial scheduled in this case. We'd ask also that a final pretrial be scheduled, but we'd also ask for another pretrial that's maybe not as far out as I'm assuming the trial is going to be.
Okay. So the lower of the two case numbers is the 7-7 case. That is the delivery manufacturer methamphetamine case. How long do you think you need for a trial in that case?
I think 2 days should be sufficient.
That's what I was thinking, Your Honor.
Okay, Ms. Clark, can you find us a 2-day jury trial date for Mr. Edwards, please?
Tuesday, September 30th at 9 a.m. and October 1st, Wednesday at 10:30.
That works for me.
So Mr. Fry and I had another case in Judge Anzalone that they were proposing that for our new trial date, the 30th to the 2nd. I don't know. Do you have a preference which case we do that on those days?
Yeah, if they propose those dates, I must have not seen that, I guess. I'm not sure. But I would probably rather do that one because I think he's in prison.
Custody, correct. So yeah, if we could get another set of dates, that would be great.
Tuesday, October 7th at 9 and Wednesday, October 8th at 10:30.
Okay, yeah, no, I'm in trial in Judge Anzalone on those dates.
Thursday, October 9th at 9 and Friday, October 10th at 9.
That should work.
I can do that.
Okay, so that's October 9th and 10th, both at 9 a.m. Do a final pretrial then on October 1st at 8:15. And then Mr. Fry, you wanted another pretrial before that. When did you want to do that?
3 to 4 weeks if the court has available.
Okay, so we can do July 16th at 8:15.
That works for me.
Fine.
Okay. And then we will set the 22178 case for a pretrial on the same July 16th date. Is there anything else that we need to address with these cases today?
Not from the people.
No, Your Honor.
All right, thank you then, Mr. Edwards. You can let the officer with you know that you're done with court for today.
Can I say something? Was I able to speak?
Mr. Fry, you want him to address the court directly?
Your Honor, I believe he's going to ask about bond, but that's probably best dealt with through a motion. Unless the court wants to hear it today, I can argue it.
You previously addressed bond at when he was arraigned on the bench warrant. Is there anything that's new that's happened between then and now?
I think the only two new things, Your Honor, are Mr. Edwards' medical condition, as he has an infection in his leg in jail that is not responding to the antibiotic treatments that they're giving him. He believes he'll likely need some IV treatment for that, but he has, according to him, has fluids and things running out of his leg currently while in jail, which is obviously very concerning for his health condition. The other issue that he brought up to me was that the mother of his child is attempting to move out of state, and he can't contest that while he's in jail. So we would ask for a bond reduction, or he's willing to wear a GPS tether.
Mr. McCready, anything you want to say about the bond issue?
We'd object to any change in his bond conditions unless the jail is willing to say that, you know, they can't adequately take care of him health-wise.
All right, at this point, as we've discussed, Mr. Edwards has had a bench warrant for a failure to appear at a previous pretrial. Court set bond after that. I think it remains appropriately set. If he needs additional treatment, the jail has the ability to take Mr. Edwards to the hospital for additional treatment for his leg. And he does have the ability to participate in court hearings related to a custody dispute from the jail. And so I don't think that that is a reason at this point to modify the bond condition. So I would deny that request.
Thank you, Your Honor.
Thank you, Your Honor.
All right, Mr. Edwards, you can let the officer that's with you know that you're done with court for today.
All right, thank you.
All right, Mr. Dagger-Margosian, are you ready to proceed with Mr. Miller?
Yes, Your Honor, thank you.
Okay, Mr. Miller, you can come forward and sit at the table here closer to the television screen. This is file 25-22221-FH, People versus Sean Kenneth Miller. We're here today for an arraignment in this case. We are proceeding today partially by Zoom and partially in person. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Bayoneto.
Alex Bayoneto for the people.
Your Honor, Michael Dagger-Margosian for Mr. Miller.
I apologize. So we had actually had in this case previously a waiver of the arraignment, and then I do have filed this morning an amended information. Mr. Dagger-Margosian, have you received a copy of that?
Yes, Your Honor.
Okay, and so what we need to do is arraign Mr. Miller on the amended information. So Mr. Dagger-Margosian, does Mr. Miller wish to have that amended information read at this time?
No, Your Honor.
And do you know how he would like to proceed?
Your Honor, on the arraignment portion of this, on the new charges, we would plead not guilty, ask for a pretrial. My intention, I did speak with Mr. Bayoneto yesterday. My intention upon learning of the amended information was to ask for a remand to district court to start the process of litigating the matter. I would ask the court, if allowable, for an adjournment so that I can continue to speak with Mr. Bayoneto and see if we can find a resolution on this case. So rather than requesting a remand today, I'd ask for an amended pretrial, adjourned pretrial.
Okay. So we'll enter a not guilty plea on the amended information of charges in the amended information and can set it for a pretrial. We can do July 9th at 8:15.
That's fine, thank you.
Is there anything else that we need to address with the case today?
Your Honor, I would ask to be heard as to bond relating to the new cases, or new charges when the court feels that time is appropriate.
All right, go ahead.
Thank you, Your Honor. When bond was first addressed in this case, I believe in district court, there were only 3 charges, low-level felonies, which guidelined to 0 to 3 months in jail. I think there's been a very clear change in circumstance with new evidence that just came to light. We did know this evidence was coming. Mr. Miller was forthright in that with Detective Gowans from the Sheriff's Department. However, Your Honor, we did not know the extent of what would be found in Mr. Miller's phone when it was searched. As you can see from the charges, Your Honor, there's a significant amount of child sexually abusive material contained in Mr. Miller's phone. I think now circumstances have clearly changed. Mr. Miller goes from guidelining to probably no jail time to guidelining to a very serious prison sentence, potentially decades. I think that presents a very clear change in circumstances that would make a cash bond appropriate now. I would ask that the court remand Mr. Miller at this time and set a cash bond as it relates to these new charges.
Mr. Dagger-Margosi?
Your Honor, I disagree that there are any change in circumstance here. Number one, the added counts here are in the same nature as what he was charged with. In other words, it's not a new criminal act. It's not a new event. He's been 100% compliant on bond for however many months he's been on bond. As Mr. Bayano indicated, he had been forthright to the prosecutor's office, to detectives. They knew that this information was out there. That would have played a role in his initial bond setting. He has literally zero criminal history of any kind. He's come to every court hearing, so I don't really understand how adding counts, even of the nature of what they've added today, changes the two prongs of bond, whether he's going to show up to court, which he has, and whether he's a danger to community, which he's not. This is these are the same circumstances as what they were at the initial bond hearing. He's been compliant. There's absolutely no reason to amend bond, and the request I view as offensive. I'd ask the court to deny that request.
All right, so the purposes of bond are to protect the public and to ensure that someone appears at their court hearings. Mr. Miller has appeared here today knowing that the additional charges were added. In terms of protecting the public, he does have conditions that prohibit any computer access and any contact with anyone under the age of 18. There hasn't been any suggestion that he has violated or had a problem with those bond conditions in any way. I think in light of those circumstances, it appears that his current bond is doing the job that it needs to be doing. I don't think that the addition of additional charges to me would justify imposing a higher bond at this point. So I'm going to not deny that request and leave the bond as so. Mr. Miller, your next court date was July 9th at 8:15 a.m.
Thank you.
Sure.
Okay, Mr. Hagglethorne, are you ready to proceed with Mr. Nimer?
Yes, Your Honor, we are ready.
Okay, these are files 24-21792-FH, 24-21872-FH, and 24-21873-FH. People versus Bailey Assad Nimer. We are here today for a pretrial conference in these cases. We are proceeding today by video conference. First, can I have the attorneys placed their appearance on the record, beginning with Ms. McClure.
E.V. McClure on behalf of the people.
Jason Hagglethorne appearing via Zoom on behalf of defendant Bailey Nimer.
Thank you. And Mr. Hagglethorne, where do we stand with Mr. Nimer's cases today?
Mr. Nimer was, I'm not sure if there was an arraignment scheduled for today or a contempt issue as well. That was what I was informed by.
Sorry to interrupt. He was arraigned on that, I think, Monday morning.
Okay. And I was told by Mr. Frey that there would be a reevaluation of that. I am getting up to date on these cases. I have met with Mr. Nimer several times in the last probably week and a half. I have handled other matters for Mr. Nimer in the hopes of wrapping everything up. And I had spoke with Mr. Sneed prior to Mr. Nimer being transferred back to Lenawee, and I would request a little bit of time just to get up to date on discovery. But I did want to, and I had spoke with Mr. Sneed about this briefly, but I wanted to ask the court for a bond consideration. I'll have Mr. Nimer put this on. I want to do this for my own protection, but Mr. Nimer has a condition. I just want him to give me permission to put it on the record before I do, if that pleases the court.
Go ahead.
Yes, Your Honor, I do give permission.
Okay, and Your Honor, that condition is a drug habit, and all of the charges that are in the Lenawee court system are pretty much arising from the drug habit. Mr. Nimer was informed me he was taking approximately 6 oxy a day, and he had some other dependency issues. I wanted to ask the court if they would consider a release to an inpatient facility once the inpatient facility was secured. We were presently looking into 2, one being Dawn Farms, the other one being Harbor Light. Both would provide inpatient. We would ask for a tether upon that release. Of course, Mr. Nimer has an additional issue. He was being held in Wayne County Jail, which is one of the reasons why he was not present at the May hearing. He was transferred over from there, and while an inmate in Wayne County, he was assaulted and he received a broken arm or a broken hand. He does need to consult with an orthopedic that was recommended by the Wayne County Jail physicians and medical personnel there. He was transferred before he could get that service there. I know that it may be within the jail's ability to do that, but being a fresh break, I do know, and I have pretty extensive experience in the medical field of litigation, that if that bone heals improperly, it's going to be a much more invasive fix surgically. So I'd probably request the court's mercy to allow him to get that evaluation by an orthopedic, or at least have the jail expedite that substantially, because any waiting is going to fuse the bone in the proper status. I mean, he's going to be at risk of tears of ligaments and tendons, and it's just going to complicate the healing process. But more importantly is that the rehabilitation, and we understand that Mr. Nimer may be doing jail time as a result of the pending charges. And it's just our position that if he can get proper tools, the tools that are going to be provided at Dawn Farms or Harbor Light are going to far exceed the available treatment that's going to be available either in the county or if hopefully not, but a prison system. And we just ask the court to consider a tether release to one of those facilities. And if the court is willing to release on a bond with the tether.
Ms. McClure.
I don't have a ton to add as it relates to bond, other than to say that we've struggled with coming to a resolution on this case because Mr. Nimer has either failed to appear or failed to meet with his attorney in a timely fashion. And I think this is maybe his 3rd attorney that for whatever reason that he's gone through. So with that in mind, I would just leave it in the discretion of the court.
And Your Honor, just to address that point, because that is a valid point made by the prosecution. I would be actually the fourth, but the problems with the attorneys arise from his initial attorney had to withdraw. He was appointed a second attorney, and forgive me for not knowing his name, but he became elected as the county commissioner, so he had a conflict of interest and he had to withdraw.
What's today, June?
And then Mr.
June 18th,
Mr. Frey was
2025.
appointed, and at that point, Mr. Bailey or Mr. Nimer and Mr. Frey never connected. I had spoke with that, and I believe Mr. Frey was only appointed for a very brief period of time, and he did not connect. So there has been some issues with attorneys, but all of those issues have been outside of the control of Mr. Nimer, and it's not necessarily, to the best of my understanding, an ability to meet with them rather than conflicts and stuff like that.
I would, it has been at least both. I know that we have had a number of adjournments in which Mr. Nimer's attorneys have requested that he contact them and meet with them to discuss the case and come back at the next pretrial hearing, and that has not. And so these are old cases that have been delayed for several reasons. Some of those reasons are the responsibility of Mr. Nimer, and some of them are things that have been outside of the control of Mr. Nimer. So I appreciate that. I also appreciate that there is a substance abuse issue here, and I'm generally sympathetic to helping people get assistance with substance abuse issues. I have probably more hesitation in this case than in many, because there has apparently been new charges that have come while Mr. Nimer has been on bond for these 2024 cases, both here in Lenawee County and apparently something also in Wayne County. So I have a difficult time providing for releases to get treatment where people are continuing to engage in, apparently appearing to engage in criminal activity that goes beyond just the substance abuse issue. I realize that it's related, but the new allegations, as I understand Mr. Nimer's to be, involve impacting other people, not simply using or possessing substances. And so I have a lot of concern about a release at this point.
If I may, Your Honor, the charges in Wayne are, I mean, we've picked those up and we've addressed them. They are resolved. They were, it was a misdemeanor retail fraud that was pled to, and I mean, it's most definitely a substance abuse related crime, as the court's well aware that when you get people in, especially with the opiate addictions, that they generally have that type of issue. The crimes relating to the individual, I believe that upon addressing that, some things are going to come to light that are going to raise a lot of questions as to the allegations. I don't believe that those will necessarily stick. I mean, I'm not going to litigate that, and I'm not going to make an argument because I know nobody's prepared to do that at this point. But one more aspect that I would ask for, at least a bond, is that I do believe these crimes all came together within roughly a year's time, maybe 8 months' time. Most of them were charged. And I did want to have Mr. Nimer evaluated mentally as well, because upon interviewing both Mr. Nimer as well as family members, including his mother and grandmother, he does have a long history of anxiety, depression, PTSD, and from the actions taken, I not being licensed, but I would suspect a bipolar in there too. And I believe a lot of the substance abuse is probably a self-medication. So in those types of instances, either Dawn Farms or Harbor Light, I do believe they can also provide at least partial mental health evaluations to address those issues, which may mitigate, at the very least, sentencing, or may have an impact on that would be beneficial to his rights inside of this criminal proceedings before the court. I realize that it is a lot to ask. I realize that, the court's put into a position of a balance of rehabilitating versus insurance of public safety and Mr. Nimer appearing at the court dates. But I believe that if we did do a tether, that would definitely secure his appearance and his location. And just from my own instance, I do believe Mr. Nimer is sincere in receiving the treatment and the evaluations, and I do believe he would abide by the court's order on this. I've got very close contact with his mother, with his grandmother, and he has contacted me at every request. I've informed Mr. Nimer that this is it's no nonsense. You will call me when I need the calls, and you will appear when you're supposed to appear if you're out on bond. I do believe he will abide by that, and I realize that it's a big ask, but I would ask for the court's mercy and the allowance, at the least with the tether.
Ms. McClure, did you want to say anything else at this point?
I don't have anything to add, Judge.
All right. At this point, I am going to allow Mr. Nimer to be released on a GPS tether directly to a residential inpatient treatment facility. If for any reason he leaves that facility, he needs to return to the Lenawee County Jail.
I thank you very much for that, Your Honor. The next question I do have for the court then is, we are in the process. We'd initially looked into Brighton. Brighton did not take his insurance, so we're in the process of that. How does the court wish to proceed as to, obviously, I don't think we're going to get him in today, but I do think we'll be able to get him in within the next week or so. How does the court want to handle the release? Pending at least the intake of the facilities.
So once it is set up and he has been approved to be transferred to a facility, then he can be released. So
okay, and would the proof just be taken to the jail?
I'm sorry.
I'm sorry for interrupting, but I was just asking, would the intake documents just be taken to the jail, or is the court going to need a motion?
So, you can work with Darren Coast in Lenawee Pretrial Services. It's KOST. And provide the information to him, and then we'll communicate with the jail.
Thank you very much, Your Honor. And Ms. McClure, could I give you a call when we're off of this? Are you going to be available?
It's not my case, it's Mr. Sneed's case.
Is Mr. Sneed available today? Do you know?
He should be, yeah.
Okay. Let him know. I'll give him a call then.
Okay.
All right. And I'm sorry, did we establish a next date for Mr. Nimer's cases?
We have not yet, Your Honor.
All right. How much time did you want Mr. Hagglethorne before the next pretrial?
If we could come back in August, I think that'd be more beneficial. That'd give me some time to get the documents. And I know from the talks with Mr. Sneed, I'm actually hoping to wrap all of the cases up. I don't know if that's ultimately going to be the possibility, but that'll give me ample time to review everything and maybe work a deal with Mr. Sneed.
All right. How about August 6th at 8:15.
I do have a conflict on the 6th, Your Honor.
How about the 13th?
The 13th would work. And I'm sorry, what time, Your Honor?
8:15.
Yes,
And
sir,
Judge
that
Earl
works.
can do the stip in order to adjourn that.
Okay, thank you, Ms. McClure. Anything else we need to address with these cases today then?
Not from my side, Your Honor.
No, thank you.
Okay. Sir Nimer, you can let the officer with you know that you're done with court for today then.
Okay, is there any way that I can speak with my attorney one last time before or should I just call you?
Yeah, you can give me a call.
Okay, thank you, Your Honor. I appreciate it. Thank you very much.
Thank you, Your Honor.
Okay, thank you. Okay, Ms. Underwood, I have Mr. Van Dyke is here in the courtroom. Do you need to speak to him? Ms. Underwood, are you there?
I'm here. I'm sorry, who, Your Honor?
Sorry, it's Mr. Van Dyke. He is has an alleged personal protection order violation and he requested an attorney.
Oh, all right. I would be more than happy to speak with him.
Okay, Mr. Van Dyke, do you want to step outside? There's an iPad right outside the door.
Van Dyke.
If you help him turn the camera.
Hi, it's Kelly. Could we have Landon Thompson? Thank you.
We're all.
Your Honor, we have absolutely no information on Mr. Van Dyke.
I will have it emailed to you right now. Okay, Mr. Noe, are you ready to proceed with Mr. Maples?
Can I have a brief breakout with him, please?
Oh, I'm sorry. I thought you had already done that.
No, I didn't. The option didn't pop up for me.
Okay, give me just a second. Mr. Malero, do you need a breakout session with Mr. Thompson?
I do not believe so.
Right, 1 second. This is file 23-21521-FH, People versus Landon Thompson. We are here today for a hearing on an alleged contempt of court for failure to appear at sentencing. We do have sentencing set for July 17th at 2025 at 8:15 a.m. First, can I have the attorneys place their appearance on the record? Do we have anyone from the prosecutor's office that's going to appear on this?
I can appear. I just wasn't sure if he needed a prosecutor or not. Phoebe McClure on behalf of the people.
Salvatore Malero on behalf of Landon Thompson.
All right, and Mr. Malero, where do we stand with Mr. Thompson's case today?
Your Honor, I had an exchange with Mr. Bayonetto about whether there may be an absconding charge on this case, and he responded that there wasn't anything in the works. So that being said, I would be more than willing to have Mr. Thompson admit to the contempt charge, and then I would ask the court to consider an argument for a reduction in bond.
Okay, Mr. Thompson, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Landon Thompson?
Yes, sir.
Do you understand, Mr. Thompson, that the maximum possible penalty for a contempt of court is up to 93 days in jail or up to $7,500 in fines?
Yes, Your Honor.
Are you satisfied with Mr. Malero in the advice that he's given?
Yes, Your Honor.
Do you understand that you have a right to contest the contempt of court charge and to have a trial on it?
Yes.
Do you understand that throughout that trial, you would be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yes.
You have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions. You also have the right to have me order any witnesses that you have for your defense to appear at your trial. Do you understand all of that?
Yes, Your Honor.
You would not be required to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes, Your Honor.
On the other hand, you would have the right to testify at your trial if you wanted to testify. Do you understand that as well?
Yes.
How do you want to plead to the charge that you violated your bond conditions by failing to appear at sentencing?
Guilty.
You understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained.
Yes, Your Honor.
Has anything been promised to you in order to get you to plead guilty?
No, sir.
Has anybody threatened you in any way in order to get you to plead guilty?
No.
If I accept the plea, you'll be giving up any and all claims that the plea is given as a result of threats or promises that were not disclosed to court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty today?
Yes.
So you had pled guilty to several offenses in the underlying case back on June 12th, 2024. Is that correct?
Yes, Your Honor.
At that time, we set the sentencing hearing for July 18, 2024 at 8:15 a.m. Is that also correct?
Yes, sir.
And you did not appear here in court for that sentencing hearing. Is that correct?
Yes, sir.
All right, I will accept that plea. It's been given understandably, voluntarily, and accurately. Mr. Thompson has had full knowledge of his rights, and he has had competent counsel. Mr. Malero, do you want the court to proceed with sentencing now, or do you want to wait until the sentencing on July?
Judge, I would ask to put, the sentencing off to July 17th. and then asked to be heard on bond.
All right, what is he like to say about bond?
So, Your Honor, Mr. Thompson, 21 years old, not entirely sure what his thinking processes were when he did not appear on the underlying charge, but if the court recalls, when the courts was in its youthful throes, sometimes we do foolish things at that age. But I can say this, Mr. Thompson, I've spoken to him a few times, verified some information from him. He was living in Napoleon, Ohio, and I know that is always a concern for the court when we're outside the state jurisdiction. But I did verify that he was employed at the Burger King there and had been so for approximately 6 months. I spoke to his one of his supervisors by the name of Renee. She indicated that he would have his job available. He would have to reapply, but she did not speak poorly of his employment duration while he was there. So I would ask the court to consider a bond reduction so that Mr. Thompson can do a few things here for the court. One, show this court that this failure to appear, for which he's now taken credit, responsibility for, was an anomaly. Two, that he can get back to work and prove to this court he can become a productive member of society. And third, also show the court that this not appearing was just a one-off and he's ready to do the right thing. I did explain to him that for whatever reasons, if he thinks things are going sideways, that's the point and purpose of having an attorney, is to see if we can resolve the problem without him facing additional incarceration. He said he understood that and would seek to make sure he followed through on maintaining contact with his attorney going forward. So based on those reasons, Your Honor, that would be my request that the court consider a considerable reduction in bond in this matter. Thank you.
Ms. McClure, anything you would like to say about the bond issue?
I don't have any other information to provide the court.
So the difficulty I have here is that Mr. Thompson, had an opportunity on bond the first time to do the right thing and show the court that he was going to be responsible. That's what the initial bond is about. And for whatever reason, made the choice not to appear at sentencing and was absent for close to 1 full year from his failure to appear until the time that he was arrested on the warrant. So, also didn't recognize at any time during that year that he needed to do the responsible thing and come back to the court and take care of this. one of the consequences of making a decision like that is that it's difficult, if not impossible, to trust someone the next time they say, okay, this time I'm really ready to be responsible. Because the track record doesn't support that. And at this point, I'm just not willing to take another chance that we go through the same thing with Mr. Thompson, having gone through it once before. So I think that the bond is appropriately set given the circumstances of this case and in that request.
Okay, Your Honor, thank you.
Mr. Thompson, you can let the officer that's with you know that you're done with court for today, and we'll see you back on your sentencing date.
All right.
Okay. Everything's on the screen.
Mr. Malero, Mr. Dunning is here in person. Will you need to speak to him?
Yeah, I do.
Mr. Dunning, if you'll step outside, there's a iPad that you can talk to Mr. Malero on, and could you call the jail for Mr. Madison? Okay, Mr. Noe, are you ready to proceed with Mr. Maples?
I certainly am.
All right, this is file 23-21397-FC. People of State of Michigan versus Stephen Maples. We're here today for a pretrial conference in this case and proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
Oh, Judge, I'm here on this one. Allison.
Yeah, I'm sorry.
No problem.
Good morning, Your Honor. Charles Noe on behalf of Mr. Maples.
All right, and Mr. Noe, where do we stand with Mr. Maples' case today?
Your Honor, this court set a scheduling order on this matter and also set some jury trial dates. We want to keep those as is for the time being. We are working on with an independent expert on getting the ball rolling on some possible defenses and a couple other things. That it's just kind of come to fruition. And I've been in communication with Miss Arnold about that. Her and I've been communicating several times about this. So what we'd like to do, just so we can keep tabs on this case, is set this matter out for another pretrial. Miss Arnold recommended a couple weeks, 2-3 weeks is fine with me. If the court has that kind of availability, but that's kind of what we'd like to do going forward. Is that correct, Miss Arnold?
It is, Your Honor. We would ask for a pretrial maybe the week after July 4th, so the 9th if the court has it, or the 16th. If Mr. Noe's expert, I think at least by then we need a deadline of when we will have a report, because I need to get that report to an expert, have them review it. I don't know if they'll need, they may need mental health records from Mr. Maples and different things, and then they'll have to generate a report. So I need some time to do that if we're going to keep the trial dates. That's my only concern.
That's understandable.
Okay, so let's set it for July 9th at 8:15 a.m. And Mr. Noe, do you have a sense of how long you need for your expert to prepare and submit a report?
I don't, although the amount of materials to go through is quite voluminous, but I don't, but I will know by then. I'll, if not before then, as soon as I find that out, I'll communicate that to Ms. Arnold.
All right. So yeah, we're going to need an answer to that question at the next pretrial. I think if we're going to keep this moving forward on the timeline that we've set forth.
I agree.
Okay. Mr. Noe, then would you do a stipulation in order for that adjournment?
I certainly will. Ms. Arnold, may I sign that with your permission?
Of course.
All right. Is there anything else that we need to address with the case today?
No, thank you, Your Honor.
No, thank you, Your Honor.
All right, Mr. Maples, you can let the officer with you know that you're done with court for today then.
Yes, Your Honor.
Mr. Murphy, are you going to need to speak to Mr. Madison?
I will, Your Honor, please.
All right, 1 second. Ms. Underwood, are you ready to proceed with Mr. Van Dyke?
Yes, Your Honor. I have a few questions.
Mr. Van Dyke, come back forward, please. Back on the record in file 25-52373-PP, Cheryl Van Dyke versus Mark Van Dyke. Ms. Underwood, do you want to place your appearance on the record?
Well, Your Honor, first I have some questions for Mr. Van Dyke. Mr. Van Dyke, are you employed?
Pardon?
Are you employed?
Yes,
And where do you work?
Myers Boat Company.
And how much do you make, Mr. Van Dyke?
It varies. I work part-time.
Okay. Can you give us an estimate?
$200-300 a week.
$200 to $300 a week? And what do you live on?
Do I live on?
Yeah,
I have
your
Social Security.
okay. And are you represented in your divorce action?
Pardon?
Do you have a lawyer in your divorce action?
I did not know anything about a divorce action.
Okay. I assumed there was a divorce action going on. Okay.
Not that I'm.
Your Honor, I've spoken with Mr. Van Dyke, and at this point, we would ask the court to enter a not guilty plea on his behalf and set this for a pretrial in a couple weeks, Your Honor.
I will enter a not guilty plea on his behalf, but I'm just going to set this for a hearing. It's been pending for some time now, and I think we need to get it resolved. So
that's fine.
Ms. Clark, we'll need a 1 hour hearing date for this PPO violation.
Tuesday, July 1st at 10 a.m.
Does that date work for you, Ms. Underwood?
That's fine, Your Honor.
And Ms. Van Dyke is here in the courtroom. Are you have any availability issues with that date, Ms. Van Dyke? Okay, so we'll set it for July 1st at 10 a.m. Court will issue a scheduling order, and that will get mailed out to everyone.
Thank you, Your Honor.
All right, so Mr. Van Dyke, you're set for today. You need to be back on July 1st at 10 a.m.
Yes.
Right.
Mr. Van Dyke, call the number I gave you and make an appointment.
Okay, thank you.
Okay, Mr. Molero, are you ready to proceed with Mr. Dunning?
I am, Your Honor.
Okay, and Ms. Underwood, Mr. Drenin is here in the courtroom in person. Are you going to need to speak to him?
The name again?
Drenin?
Yes, Your Honor. If he could have a breakout.
Mr. Drenin, if you'll step outside the hallway, I'll put you in a breakout session with Ms. Underwood. This is file 25-22172-FH People versus Dwayne John Dunning. We are here today for a pre-trial conference in this case and proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure?
E.B. McClure on behalf of the people.
Salvatore Malero on behalf of Dwayne Dunning.
And Mr. Dunning is here in courtroom in person. Mr. Malero, where do we stand with Mr. Dunning's case today?
And I'm going to ask to adjourn this one additional time. Mr. Dunning has provided me some information that I believe requires to be investigated and would probably be dispositive of this matter.
Ms. McClure, is there anything we need to address from the people's side today?
Nothing on behalf of the people.
I will adjourn this to July 16th at 8:15 a.m. Mr. Malero, would you prepare that stipulation in order, please?
Yes, I will, Your Honor.
So, Mr. Dunning, your next date is July 16th at 8:15 a.m. Thank you.
And Mr. Mallory, you're just going to forward me whatever you want me to consider.
Yeah, once I verify the information, I will get a hold of you.
Okay.
Thank you, Your Honor.
Thank you, Mr. Malero.
Your Honor, are you done with me?
Yes, Mr. Malero, those were the only two I had for you today.
All right. So I take it I'm free to leave?
You are.
Thank you. Appreciate it. Have a good
Have a nice
day,
day.
Your Honor.
Okay, Mr. Dren, you can come forward, please. Okay, we are on the record in file 21-20300-FH People versus Joshua David Drenin. We are here for a hearing on a probation violation. We are proceeding today partially in person and partially by video conference. All right, we didn't have Ms. Underwood, we have Ms. Underwood now. So again, we're on the record as People versus Joshua David Drenin, here today for a hearing on probation violation. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Drenin this morning, Your Honor.
And where do we stand with Mr. Drenin's case today?
Oh, Your Honor, I've discussed this case with Mr. Drenin and with Mr. Moore a couple times, Your Honor. And I believe we've come to an agreement. And Mr. Drenin is very aware that this agreement he needs to live up to because there are going to be no exceptions. Mr. Drenin is going to pay $40 a month. Mr. Drenin's probation will be extended a year, and Mr. Drenin will pay $40 a month. And I believe this show cause will be withdrawn at this point, Your Honor. But it can come back in the future the minute Mr. Drenin does not comply, Your Honor.
All right, and Mr. Moore is here in the courtroom. Is that all accurate, Mr. Moore?
That, in addition, you know, he needs to make legitimate efforts to gain employment. We haven't had employment in, you know, for 4 years here, except a little bit of little things here and there. But for the past, I don't know if you could elaborate a little bit more. It's been at least a year or longer since any employment, and 40 at a minimum, but we need to try to expand on that because, you know, the restitution's thousands of dollars.
Okay, so if that is the plan going forward, I'm willing to go along with that at this time. I will say, Mr. Drenin, been on probation since 2021, and according to the Register of Actions, you paid $30. It's time to start doing what you need to do, because if you don't, there's going to be a different action. You're on a really short leash at this point. So you need to find a job. You need to start making payments. You do have a significant amount of restitution here to pay, and so I'm going to expect a real effort toward that. Just time to get this done. All right. So if that's the case, then I will sign an order amending the probation as soon as that's presented to the board.
I'll prepare that, Your Honor.
Okay. So you're all set for today, then, Mr. Drenin. Okay. Okay, Ms. Underwood.
I'm sorry, Your Honor. Some voice came up right then.
Yeah. Do you need to speak to Mr. Lindsay?
Yes, please, Your Honor.
Okay, Mr. Murphy, are you ready to proceed with Mr. Madison?
I am, Your Honor. Thank you.
All right, it's file 24-21996-FH and 24-21997-FH. People versus Brandon Madison. We are here today for a pretrial hearing in each of those cases, as well as a pending contempt for alleged failure to appear. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Bayonet.
Alex Bayonetto for the people.
Matthew Murphy, appearing on behalf of Mr. Madison.
And Mr. Murphy, where do we stand with Mr. Madison's cases today?
Your Honor, there's a plea offer in this matter from the people that would encompass files that are down in district court right now. And Mr. Madison has an intention of accepting that offer. So I was going to ask the court if we could adjourn this, maybe, a week. I'm hoping to contact the district court and squeeze Mr. Madison in this afternoon to maybe waive those files and get him up as fast as possible. So again, I didn't know if the court would be willing to do maybe a week from now, and hopefully the files can get up there in time. I forget if Wednesdays would be fast enough or not for the next week. And if that didn't work, then obviously the week after that would be sufficient. I will be out on vacation, but if the court wanted to schedule the week after that, someone from my office can cover and take the plea for Mr. Madison.
Okay, I can't do it next week, but I can do the week after. That'd be June 25th. No, actually, that would be, look at the calendar. June 25th is next week. Looks like we can fit one more in on the 25th, so we can do that.
All right, thank you, Your Honor. Hopefully we can get the other files up before Your Honor by then.
Okay, so Mr. Murphy, would you be willing to do a stipulation in order for that adjournment?
Yes, Your Honor.
Okay. Anything else we need to address with the cases today?
No, Your Honor. Nothing from the defense. Thank you.
Nothing from the people, Your Honor.
All right, Mr. Madison, you can let the officer with you know that you're done with court for today then.
Yes, sir.
Okay, Mr. Madison, thank you. I'll hopefully see you later this afternoon, okay?
All right.
Mr. Murphy, Mr. Bosel is here in the courtroom. Do you need to speak to him?
I do not. If he wanted to speak with me about anything, then I could, but I'm ready to proceed on the record if he's okay.
Mr. Bosel, did you want to? Okay, he's indicating he'd like to speak to you. So Mr. Bosel, if you'll go outside to the hallway and step to the iPad, which is breakout session. Mr. Dyke.
Thank you. Bye. Jason Lindsay.
Okay, this is file 24-21749-FH People versus Jason Lindsay. We're here today for arraignment on request and summons for probation violation and proceeding today by video conference. Sir, you are Jason Lindsay. Where do you go? He's been moved back from the breakout session. Apparently, he has not. Okay, Mr. Lindsay, are you there?
Yes, sir, I'm here.
Okay, so this is file 24-21749-FH People versus Jason Lindsay. We are here today for arraignment on a request and summons for probation violation proceeding today by video conference. Sir, you are Jason Lindsay, correct?
Okay.
You're Jason Lindsay, correct?
Yes, sir, I am.
Mr. Lindsay, have you received a copy of the request and summons for probation violation?
No, I didn't receive.
Sorry?
I'm sorry, sir. I'm sorry, sir. Yes, I just received a violation notice yesterday when I got a call from my attorney. I didn't I talked to Mr. McCarron on Monday, or I believe it was Monday, and he didn't say anything about a violation. I've started the program and I'm halfway through with it already. So but I didn't realize when I talked to him that I was in jeopardy of a violation.
All right, so you've received a copy of it now?
It might be at my house. I'm a truck driver over the road. It might be at the house. I haven't received an email on it, but I do have but I did receive a letter from him explaining how to log on and what to do. He said he sent that out back in April. But like I said, sir, I've started the process and I'm halfway through with the program already.
All right, I need an answer to a very direct question. There is a document called a request and summons for probation violation. Have you received that document?
No, I have not.
All right, so that document alleges that you violated the terms of your probation by failing to enroll in anger management or domestic violence counseling, and by not reporting since January 16, 2025. Do you understand that those are the allegations that are in that document?
Okay, yeah, I understand what you're saying.
All right. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Lindsay this morning, Your Honor, and I believe I can provide a little bit of clarity here.
Okay,
I reached out to Mr. Lindsay in anticipation of this event, even though I hadn't been appointed yet. But Mr. Lindsay was made aware of it yesterday by me, Your Honor, but I don't know if he's since got a copy. Mr. Lindsay did receive notice from Mr. McCarron earlier that he needed to get these things done and a method for doing them. And since that happened, Mr. Lindsay has been in the process of doing these things. I believe he's had. What I would ask is that the court enter a not guilty plea and set this for 2 weeks from today, if that's available, Your Honor. And by then, these issues should be taken care of.
All right, I will enter a not guilty plea for Mr. Lindsay, and we'll set a hearing date or a pretrial date on July 2nd at 8:15 and figure out where things stand at that point.
Thank you, Your Honor.
So, Mr. Lindsay, you need to log back in 2 weeks on July 2nd at 8:15 a.m.
Okay, all right.
All right, you can log out for today then. Mr. Murphy, do you need to speak to Mr. Spike?
Yes, please, Your Honor.
I'm sorry, we still need to do Mr. Bosel first. So Mr. Bosel, will you come forward, please? And then Ms. Underwood, you need to speak to Mr. Cherry.
Yes, yes, I need to speak with Mr. Skinner.
Okay. This is file 25-22292-FH, People of the State of Michigan versus Nicholas Christian Bosel. We are here today for an arraignment in this case and proceeding today by partially by video conference, partially in person. First, going to have the attorneys place their appearance on the record, beginning with Mr. Bayonetto.
Alex Bayonetto for the people.
Matthew Murphy, appearing on behalf of Mr. Bosel.
And sir, you are Nicholas Christian Bosel, correct?
Yes, Your Honor.
All right, Mr. Murphy, does Mr. Bosel wish to have the information read?
No, Your Honor, we acknowledge receipt of the information, the witness list, and the discovery demand from the prosecution in this matter. There was a preliminary examination held in this matter. We did put in an order or request for an order on the transcript on that. Would ask the court to set a pretrial on this matter. It is our intention to file a motion to quash once that transcript is prepared and delivered. We would ask the court to set a pretrial on this matter, whatever fits the court's schedule best. I did want to place on the record that there was an examination held. The officer that testified at the examination, his body cam footage was provided to the defender's office on the V drive in a format unlike any of the other files that we had or any other files that we do have. I haven't been able to figure out a way to watch that, and I provided Mr. Bosel copy as well. So obviously he hasn't been able to watch that either. So again, I'm trying to figure out with IT if there's some way to watch that. If not, I'm going to request that the prosecutor's office resend that in some other fashion. I just wanted to place that though on the record.
All right, I don't see in the file that I have a request for the preliminary exam. Did that happen at the district court level, or I just want to make sure
we haven't filed it yet. I guess it's got to be filed today.
Okay, I just want to make sure if there's something I need to do that I do it.
No, Your Honor.
All right, so court will enter a not guilty plea for Mr. Bosel. And I'm sorry, Mr. Murphy, how far out did you want to go for a pretrial?
Your Honor, whatever fits the court's schedule best. There is a preliminary examination on some other files that's being held, I believe, sometime later in July. But I intend to file a motion on this. So I believe the next pretrial, I don't know if there be any leeway at that point or if there be any change in the case or not. So at this point, again, I'm just whatever the court finds what fits its court schedule best.
July 24th is that next preliminary exam, Your Honor. If the court wants to maybe go to August 6th, then we can have an idea where we're at.
Okay. I think that would make sense. I think if it were to get bound over, that would be my next Wednesday. So then we'd have them all on the same date. And given that we're going to have a period of time waiting for that transcript to get prepared, I don't see any sense in having one before then, unless Mr. Murphy thought that was necessary for some reason.
If there was a reason, I'll contact the court, Your Honor.
So we'll go with August 6th at 8:15 a.m. for a pretrial. And let's see, this was an arraignment, so the court will send out the notice.
Thank you, Your Honor.
So Mr. Bosel, your next day is August 6th at 8:15 a.m. You can attend in person like you did today. If you prefer to attend by Zoom, you can do that, and bailiff has our Zoom information.
Thank you.
Thank you.
Thank you, Mr. Bosel. I'll be in touch with you soon, okay?
All right, thank you. Okay, and then Mr. Murphy, you wanted to speak to Mr. Spike, is that correct?
Yes, Your Honor, please.
Give me just a moment and I will set up that breakout session.
Derek King in wrongful judgments. Thank you.
All right, this is file 22-20683-FH People versus Paul Cherry. We are here today for a hearing on a probation violation. We are proceeding today by video conference. Sir, you are Paul Edward Cherry?
Yes, sir.
All right, and Ms. Underwood, you want to place your appearance on the record?
Ron Underwood for Mr. Cherry this morning, Your Honor.
All right, where do we stand with Mr. Cherry's case?
Your Honor, Mr. Cherry is in the midst of a Chapter 13 bankruptcy, of which that listed, Your Honor. So based on that, we would stay these proceedings.
I'm sorry, your audio cut in and out, and I wasn't able. I heard something about a bankruptcy, and that was about it.
But Mr. Cherry has filed a Chapter 13 bankruptcy, Your Honor, and this is listed in that bankruptcy. And I believe we are requesting that this matter be stayed or adjourned to allow the payment plan to be implemented and the bankruptcy to go forward. Mr. Cherry's bankruptcy attorney did say he was going to provide some proof to the court.
If I may, Your Honor.
Ms. Underwood, you want him to address the court directly?
Yes, sir.
Mr. Cherry?
Yes, sir. Yes, please.
Is there something else?
Mr. Chair, I wasn't asking you. I was asking Ms. Underwood. She is your attorney, and I'm asking her if she wants you to address the court directly.
Oh, I'm sorry.
Mr. Cherry, is there anything else you would? I believe
I was just told to give the court the case number for this.
Okay, if you would like to give the court the case number, you may do that, Mr. Cherry.
Okay, I'll just do it right now. It's 25-43880.
right, what I'm going to do at this point then is set this out to August 13th at 8:15 a.m.
Thank you, Your Honor.
All right, so Mr. Chair, you can go ahead and log out for today.
Thank you, sir.
Thank you. Okay, Ms. Underwood, do you need to speak to Mr. King?
Yes, I do, Your Honor, but first I'd like to check, do we have a Patrick Skinner or a David Spencley?
I do not have either of those people logged in.
Okay, thank you.
Okay, this is file 25-22288-FH People versus Benjamin Paul Spike. We are here today for an arraignment in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Bayoneto.
Alex Bayoneto for the people.
Matthew Murphy appearing back from Mr. Spike.
All right, yeah, Mr. Murphy, does Mr. Spike wish to have the information read this morning?
No, Your Honor, we acknowledge receipt of the information, the witness list, and the discovery demand by the prosecution in this matter. Would ask for the court to enter and continue a not guilty plea for Mr. Spike and set a pretrial on whatever fits the court's schedule best. I do believe that this case will probably be resolved by the first pretrial. That's my understanding, my anticipation at this point. Just haven't got a solidified offer in place. But I would ask the court to do that. And then if I could briefly address bond after we set that pretrial.
I'll enter a not guilty plea for Mr. Spike set for pretrial on July 9th at 8:15 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
What is it you'd like to say about bond?
Your Honor, Mr. Spike is charged with an R&O and a domestic violence, not to diminish the severity of resisting and obstructing an officer, but it is a fairly minimal felony. It did involve him in an interaction in front of Myers involving his father. And the interaction with the police officer from the body cam, it seemed to be more out of confusion and trying to get an understanding of what ultimately was occurring, as opposed to Mr. Spike trying to defeat the officer and escape his authority and custody. So because of such, I don't believe that Mr. Spike is a threat to community. I don't believe that incarceration is necessary in this matter, pending the outcome of the file. Again, I believe that it'll be resolved here fairly quickly. Now, he does have a cash bond, but he has no way of paying any bond, any cash bond. So I was asking the court to consider a personal recognizance bond. Now, again, Mr. Spike understands that he has there's a no contact in place involving him and his father, and I guess as well as a police officer, Mr. Victor Duarte, in this matter. He understands that order applies to him. He's under the authority of the court, that he has to avoid any contact with his father, even if his father was to want to contact him, until the court was to change that order. So again, I don't believe that there's any threat to society, nor is there any need to have him incarcerated because of a risk of failing to appear. He can be notified of court. He doesn't have a history of not appearing before the court. And so I do believe that he will appear moving forward. And I don't believe that he will, delay the case any unnecessarily long than it needs to be. So I would ask the court to consider a pre-hour bond. He does have an address he can provide the court on the record that he will be available at, just for the court's record. But again, I don't believe that custody, further custody is necessary for him. So again, I would ask the court to consider a PR bond.
All right, Mr. Bayoneto.
Your Honor, I defer to your discretion.
from what I can see in the file, it all looks consistent with what Mr. Murphy has described. I think in light of those circumstances, I am willing to modify the bond in this case. It's currently set at $6,000 cash or surety. I would convert that to a $6,000 personal recognizance bond.
Thank you, Your Honor.
Thank you.
Mr. Spike, you need to understand that all the other bond conditions about no contact remain in place, so you can't have any contact with any of those people.
Yes, sir.
All right, anything else we need to address with this case today, Mr. Murphy or Mr. Vanita?
No, Your Honor.
No, Your Honor, just Mr. Spike, contact my office as soon as you can. Give me an update on any information, okay?
Yes, sir.
All right, Mr. Spike, you can let the officer with you know that you're done with court for today.
Your Honor, what was that pretrial date? I apologize, I missed it.
July 9th.
July 9th.
Sorry, I didn't mean to intervene, but
No, I appreciate it. So July 9th, yeah. All right, Mr. Spike, you're all set.
Thank you.
Ms. Underwood, did you get your chance to have a breakout with Mr. King?
I did not, Your Honor. Mr. King never entered the breakout.
Okay. Mr. King, I'm gonna set that breakout up again. You're gonna get something on your screen that asks you to join a breakout session, and just go ahead and click join.
Okay. Thank you.
Mr. Murphy, you need to speak to Ms. Allen.
I will, Your Honor. I do need to speak with her.
All right, Ms. Allen, if you're there, I need you to unmute your device and send a request to unmute your device. Down, I need you to tap the screen on your device, and then at the bottom, there should be a microphone icon with a red slash through it. You need to tap that to unmute your device. All right, Ms. Allen, I'm going to put you in a breakout session with Mr. Murphy so that you can speak to him.
You.
All right, this is file 25-22155-FH and 25-22156-FH. People versus Jennifer Lynn Allen. We are here today for pretrials on both of those cases. There's also a new motion affidavit in order to show cause in the 22155 file. First, let me have the attorneys place their appearance on the record, beginning with Mr. Bayonetta.
Alex Bayonetta for the people.
Matthew Murphy, appearing by Ms. Allen.
All right, and Miss, you are Jennifer Lynn Allen.
Are you asking me? I'm sorry, Your Honor.
Yes, you're Jennifer Lynn Allen.
Yes, Your Honor.
Ms. Allen, have you received a copy of the motion affidavit in order to show cause?
I'm not sure. I didn't receive anything. I talked to Darren Coast and he told me that I had this today.
All right, that alleges that you violated your bond conditions by failing to drug test twice a week as directed on May 19th, May 22nd, May 23rd, and May 28th of 2025. The maximum possible penalty for violation of bond conditions is up to 93 days in jail or $7,500 in fines. Do you understand that?
Yes, Your Honor.
Mr. Murphy, do you know how she wants to proceed with respect to that alleged bond violation?
First, Your Honor, I'll just ask for clarification in regards to whether or not it's four separate bond violations or one bond violation for those four separate instances.
It would be one bond violation for the 4 missed tests.
I thank you, Your Honor, for clarifying that. Your Honor, there is an offer in place in regards to Miss Allen's files before Your Honor, as well as files that are down in district court. I discussed with Miss Allen that offer this morning. It would involve an entrance into recovery court. She was screened for that previously, but that was a bit of time ago. I know that they want updated screening. So what I wanted to ask the court to do was to adjourn this. I wasn't aware of that show cause until just yesterday. So I do apologize for not speaking with Ms. Allen before that until this morning. In regards to that, her performance on the bond, I believe well, I don't believe it. It's a matter of her not having the finances to afford the GPS tether as well as the testing regimen as it is in place. I believe if Your Honor was a tester at this time, she would test clean. But again, it is a matter of her not being able to financially meet the obligations the court has given her, and she does apologize for that. But I was just going to ask if that could be, set for another pretrial. Just a couple of weeks from now, again, I want to have her rescreened for recovery court. And I didn't know if it would be possible for Mr. Coast to maybe do an evaluation to see if the regimen could be changed at all, or if the GPS tether was still required in order to sort of reduce the financial obligation on Miss Allen. Again, I just wondering if Mr. Coast could do another evaluation to see if there would be appropriate action by the court in regards to her bond.
Mr. Coast is not here today. I do want some further input from him. The reason for the GPS tether is that she previously failed to appear. And the reason for the drug testing requirements is that these are possession of controlled substance cases. So as to the appropriateness of the bond conditions, I think they are what's necessary at the moment. And I have a concern that there apparently has been no testing for a significant period of time. So I'll enter a not guilty plea. I'm going to set this for next week, June 25th at 8:15 a.m. And I believe we'll have Mr. Coast available to us at that point.
Thank you, Your Honor. My office will do the stipulation and order return for the files for the date and time.
All right, so Ms. Allen, you need to be back on the 25th at 8:15 a.m.
Okay, thank you, Your Honor.
Thank you, Judge. I think that's it for me with you today. Have a good day.
Okay, thank you, Mr. Baynetto.
Miss Allen, I'm going to be in touch with you soon, okay?
Okay,
All right, thank you.
thank you. Do I, is it?
Yeah, you can leave the meeting.
Second.
Okay, I see. All right, thank you so much.
Okay, and then Mr. Murphy, do you need to speak to Mr. West?
Yes, please, Your Honor.
Here we are again. Hello?
Yeah.
Yeah.
1 second, Mr. West. I'm just going to change your name. I'm not sure why you're logging in with my name, but I'm going to change it to yours. I'm going to put you in a breakout session with Mr. Murphy. If you give me just a second. And okay, Ms. Underwood, are you ready to proceed with Mr. King?
Yes, Your Honor. Thank you.
This file 23-21419-FH and 25-22260-FH, People versus Derek Eugene King. We're here today for a probation violation in the 23 case and a pretrial in the 25 case. We are proceeding today by video conference. First, may I have the attorneys place their appearance on the record, beginning with Ms. McClure.
PV McClure on behalf of the people.
Rhonda Underwood on behalf of Mr. King, Your Honor.
All right, and where do we stand with Mr. King's case today?
Well, Mr. King, Your Honor, has been approved for recovery court, Your Honor. This is the first time he's been screened, and the problem has been identified, and he's been approved for recovery court. The offer in this matter, Your Honor, is as charged with no subs, with an agreement to no upfront prison time. Now, I would request, I think what I'm asking for is basically a COBS that Mr. King will be released to recovery court rather than incarceration at this point, Your Honor.
All right, so what typically happens when someone is sentenced to recovery court is that they're sentenced to, I think, 90 days in jail with approval for an early release to a residential inpatient treatment facility. If he has been, well, I guess let me ask Ms. McClure, is there anything that you wanted to address?
No, and I would agree with the court and Ms. Underwood's recitation of the plea.
Okay.
Oh, and I forgot to put in that there is a misdemeanor file that would be dismissed.
Okay, so I would be willing to, I do think that would be an appropriate sentence if he's been approved for drug court is to sentence in accordance with the kind of regular drug court provisions of a probation sentence.
Right, and I would hope that would hold true for the violation as well, Your Honor.
Yeah, I would not treat the violation in a way that would prevent him from participating in recovery.
Okay. Mr. King, under those circumstances, do you wish to accept the plea offer?
Yes, I do.
Okay, and I'm sorry, that was a plea to count 1 in 25 case?
Yes.
Yeah, yes.
All right. Mr. King, would you raise your right hand, please?
Yes.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, I do.
And you are Derek Eugene King, is that correct?
Yes, sir.
You can put your hand on if you like, Mr. King. Mr. King, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1 in file 25-22260-FH, first degree retail fraud?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 5 years in prison and or a fine of $10,000 or 3 times the value of the property stolen, whichever is greater?
Yes, sir.
Are you satisfied with Ms. Underwood and the advice that she's given?
Yes, sir.
Neither the prosecutor, defense attorney, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here today. Is that correct, Ms. McClure?
That's correct.
That's correct, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial, and explain those rights to you now to make sure that you understand them.
Yes, sir.
You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. If you have the right to be presumed innocent until proven guilty beyond a reasonable doubt, you have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. King, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
And do you understand that you're giving those rights up?
Yes, sir.
how do you wish to plead to the charge that on or about February 16, 2025 in Madison Township, Lenawee County, Michigan, that you did commit the offense of first-degree retail fraud?
Yes, sir.
If you want to plead guilty, you would need to say guilty.
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
I understand.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. King to plead guilty today?
None, Your Honor.
None, Your Honor.
Mr. King, other than as we've talked about it on the record this morning, has your attorney promised you any particular sentence or estimated what it would be?
No. No, sir.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea agreement or sentencing agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty today?
Yes, sir.
Ms. Underwood, do you want to establish the factual basis?
Thank you, Your Honor. Mr. King, let me take you back to February 14th through the 16th of this year. Are you familiar with the mobile gas station at 2982 West Beecher?
Yes, yes, sir.
And on those days, did you go in 4 separate occasions? Did you take alcohol without paying for it?
Yes, ma'am.
And you knew no one paid for it, correct?
Correct.
And this is a store open for business, correct?
Correct.
And you meant to deprive them of that alcohol.
Yes. Yeah.
And the total of that was $553, correct?
Correct.
And you have been convicted of retail fraud before, correct?
Correct.
I believe the facts are sufficient, Your Honor.
Do you agree that that prior conviction was June 29th, 2023 for retail fraud, 2nd degree in the 2A district court?
Yes.
People are satisfied.
Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
It has.
Okay, I'll accept the plea. It's been given understandably, voluntarily, and accurately. Mr. King has had full knowledge of his rights, and he has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we've discussed it on the record here this morning. I will refer this matter to the probation department for pre-sentence investigation and set sentencing for July 24th at 8:15 a.m.
Thank you, Your Honor.
Mr. King, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about this offense and about your background.
Yes, sir.
All right, and I also need to do the plea on the violation of probation. Mr. King, do you understand that you have a right to contest the violation of probation charge and have a trial on that as well?
Yes, sir. I understand.
Do you understand that throughout that trial, you'd be presumed innocent until your guilt is proven by a preponderance of evidence?
Yes, sir. Yes.
And do you understand in that trial, you'd have all the same rights that I've already described to you that include the right to have witnesses against you appear at your trial, to have the court order any witnesses you have for your defense to appear at your trial, and that you or your lawyer could ask those witnesses questions.
Yes, sir.
You'd also have the right to testify at your trial if you wanted to testify, or not testify and not have your silence used against you. Do you understand that as well?
Yes, sir.
How do you plead to the charge that you violated the terms of your probation by not reporting to your probation agent on October 1, 2024, after you were released from jail?
Guilty, sir.
Do you understand by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes, sir.
Has anything been promised in order to get you to plead guilty to that violation of probation?
No, sir.
Has anybody threatened you in any way in order to get you to plead guilty to that violation of probation?
No, sir.
If I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty?
Yes, sir.
All right, so you were on probation in this case, and actually had a violation of probation that caused you to have to serve a jail sentence. Is that right?
Yes, sir.
And you were also required to report to your probation officer on the first day that you were released from the jail. Is that correct?
Yes, sir.
And you did not, in fact, report to Ms. Holly upon your release from jail. Is that correct?
Yes, sir.
All right. I will accept that plea then. It's been given understandably, voluntarily, and accurately. Mr. King's had full knowledge of his rights to have competent counsel. Also refer this matter to probation department for an updated pre-sentence investigation in the 23 case, and set sentencing for the same date and time.
Thank you, Your Honor.
Okay, and it also looks like there may have been a pending contempt of court for failure to appear at the original violation of probation summons. I'm just going to dismiss that in light of the guilty plea to the probation violation.
Thank you.
Thank you, Your Honor.
Okay, so I think we're all set for today then, Mr. King. You can let the officer with you know that you're done with court.
Okay, thank you, sir.
Thank you.
Your Honor, do we have anything else?
I just have the two, Mr. Skinner and Mr. Spencley, who have not appeared. Let me call those real quick and
thank you.
Those. Oh, I'm sorry, and Spencley, I guess we don't have a proof of service. I'm sorry, what's that? Okay, so on Mr. Spencley, there's no proof of service. Let me set that aside and we'll do Mr. Skinner then. It's file 2024-22029-FH and 24-22031-FH, People versus Patrick Lee Skinner. We are here today for a probation violation hearing in both of those files. We are proceeding today by video conference. The courtroom is also open to the public. There is also a request and summons for probation violation in 24-22029 file that is set for today, as well as one in the 24-22031-FH file that was set for today as well. Ms. Underwood, do you want to place your appearance on the record?
Ron Underwood for Mr. Skinner, Your Honor.
All right, the record should reflect this matter was set for a hearing this morning at 8:15 a.m. It's now 11 a.m. Mr. Skinner has not appeared either by logging into the Zoom session or by being present here in the courtroom. Ms. Underwood, anything you'd like to say with respect to Mr.
I have no knowledge as to his whereabouts, Your Honor.
Mr. Skinner has failed to appear today, obviously concerning given the allegation made in the request and warrant for probation violation summons. I am going to issue a bench warrant for Mr. Skinner's arrest in both files for the failure to appear. And I am going to set bond on each bench warrant in the amount of $50,000.
Thank you, Your Honor. Have a good day, everyone.
Ms. Underwood, Mr. Murphy, are you ready to proceed with Mr. West?
Yes, Your Honor.
This is file 20-20069-FH People versus Wendell Charles West. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, I have the attorneys place their appearances on the record, beginning with Ms. McClure.
Dean McClure, on behalf of the people.
Matthew Murphy appearing on behalf of Mr. West.
And Mr. Murphy, where do we stand with Mr. West's case today?
Your Honor, Mr. West has a case that was done in district court. We waived that examination just this week. We're to ask this case be adjourned till next Wednesday. My anticipation is that that other file will be up in circuit court by then. There will be a plea involving both files and with Mr. West's entrance into sobriety court. So again, that's all we're asking for today, just an adjournment for 1 week to get the files coordinated.
All right, Ms. McClure, is there anything we need to address from the people's side?
Nothing, thanks.
Okay, I did receive a letter from Mr. Coast that Mr. West's GPS tether was removed when he was lodged in Jackson County. Has that been put back on?
I don't know, Your Honor. I have no information about that. Mr. West, are you? Wait, is he even there?
He's got his camera off. Mr. West, I need you to start your video and unmute your device. Need to unmute your device, Mr. West.
Hello?
All right, we can hear you now.
Yeah, I can hear. I could hear you. Yes, sir.
Mr. West, what's the situation with your GPS tether?
They took it off in Jackson. They took off my tether and they took off my scram, but I have my scram on.
The scram is back on?
Yes, yes, sir. It was back on before I even walked out the door.
All right. So you also still have the GPS tether requirement, so you need to get in touch with judicial services and get the GPS put back on as well.
All right, all right. I get out work at 3:15. I can call them and go back in there and take care of that in Adrian, because they did it in Jackson. They put it on in Adrian, they took it off in Jackson 12 hours later, and then put it back
Okay.
on.
Yeah, they take it off anytime that you get lodged at a jail. They take them off because I don't think they can communicate there, and also the battery goes dead. So we just need to make sure it gets put back on.
Yes, sir. Yes, sir.
Thank you, Mr. West.
I'll take care of that.
All right, so next week we'll adjourn it to June 25th at 8:15.
Thank you, Your Honor. My office will do the stipulation order for that date and time.
Okay. All right, so you're all set then for today, Mr. West. You need to log back in next week at 8:15.
Thank you, sir. Have a nice day.
Thank you, Mr. West. I'll be in touch, okay?
Yes, sir.
Thank you.
Okay, so then we can follow the Gryinger versus Spencley case.
Your Honor, I think Mr. West was all that I had left.
Yeah, I think we're all set.
All right, so I'm gonna go ahead and log off. Thank you, Your Honor. If I'm wrong, I'll jump back on, but thank you. Everyone have a good day.
Okay, thanks. File 25-52331-PP, Nicole Gryinger versus David Dale Spencley Jr. This was set today for a hearing on an order to show cause for violating personal protection order. There does not appear to be proof of service in the file indicating that this was served on Mr. Spencley. This matter will be adjourned to July 16th at 8:15 a.m. And we will see if service has been accomplished with that.